Right, turning first of all to the purpose of today. Who are we? We're Brodies. We are the largest law firm in Scotland. We are also probably the largest contentious construction team in Scotland. We have 17 lawyers, 2 trainees operating predominantly in the Scottish market, but now starting to branch out into England more and more every year. With increasing proportion of what we do is south of the border. We're a top tier rank in Legal 500 team. What does that mean? Maybe not very much if you're not in the industry, but what it means is that we are recognised in the industry as being involved in the largest and most complex disputes in the country. There are very few infrastructure projects that we are not involved in some capacity. And I want to hand over to you now to Connor, if you don't mind, and that's so that Connor can talk you through a bit more detail about what we do and what it's like to be a contentious construction lawyer. Over to you, Connor.
Thanks, Mass, and again, just welcome everybody. So just wanted to give you a brief overview as to what contentious construction and construction law in general really is. So construction law can be split into 2 parts, that is non-contentious construction and contentious construction. So broadly speaking, non-contentious construction involves giving strategic advice on how to structure parties' roles and risks within projects, drafting and negotiating contracts, and advising on related matters. Contentious construction, as I'm sure you'll have guessed, involves resolving disputes that arise within construction projects. So within construction projects, there are a lot of moving parts. You'll see on the screen just here a simplified chart of the many contractual agreements that exist within can exist within any one construction project, and a number of parties that are involved in any one project. Within construction, the most common form of construction contract within the UK is a design and build contract. So in that contract, a main contractor will carry design responsibility and will construct the works. So in those circumstances, the contractor will be required to employ its own professional team, such as architect, structural engineer, civil engineer, for example. So you see here, just in the kind of middle left of your screen, you'll see the link to contractor, professional team, and above to the employer. There are also circumstances where a contractor will not carry out a design function, and here the developer employer will pass a design directly to the contractor. The employer will have already employed the professional team, and the contractor will simply work to that design. So in our role, we can become involved in advising on disputes between really any of these parties that you can see on your screen. We might be working with a contractor that's in dispute with an employer or a developer. We could be working for an architect that's defending a claim raised by a contractor for a defective design, for example. Or we could be working for example, the purchaser of a defective office building who's looking to pursue the original contractor for pre-existing defects. We could even be acting for a supplier of materials under a construction contract. What we find now is that some materials that are being provided are so specialised that the supplier of those materials can actually be deemed to be designers within their own right. So because there are so many different moving parts and different parties contributing to the construction project, more often than not, when an issue does arise in the project, it's not always obvious who is responsible for something going wrong. A contractor may blame a member of the professional team for their design, whereas the professional team may turn around and tell the contractor that, well, my design's perfect, it's your shoddy workmanship that's causing all the issues. The disputes that we deal with are very technical in nature, and they are far from straightforward. However, whilst there are complexities in the contractual relationships and the disputes can be technical in nature, the disputes that do arise out of the projects will broadly fall into one of 3 more simple categories: time, cost, or quality. So dealing with time first, in construction contracts, a contractor is required to complete a project or to a sufficient standard by a certain time. If the contractor fails to complete the works by that certain time, the employer may have a right to damages. So in most construction contracts, the amount of damages that are for that breach, for failure to complete in time, are fixed and agreed between the parties when they enter into the contract. These damages are known as liquidated and ascertained damages, or LADs, and they are usually expressed as an amount to be paid by the contractor per day or per week that they are in breach of contract. So if you take, for example, a project where a contractor is constructing a commercial premise which the employer ultimately intends to lease out. If that project isn't completed on time, then there's no commercial premise for the employer to lease, and the employer gets no rental income. So the parties can agree that the loss of rental income, for example, will be the amount that the employer would be entitled to per day or per week should the works overrun. It's fairly straightforward. However, what would happen if the employer was unable to find a third party to rent out the property to, i.e. if there was no tenant in place and the works were late? In such circumstances, the contractor could argue that, well, the employer hasn't actually suffered a loss. There's no tenant in place. There's no one that's going to be paying that rent. Why should I have to then pay your loss of income? However, that is where LEDs assist the employer. Provided that the LEDs clause in the contract is not found to be penal and it's a reasonable estimate of loss, a court will generally uphold that LEDs clause and the employer will not have to prove or vouch its loss. Difficulties do arise, however, where works overrun and the contractor is in breach of contract for failing to complete on time, but that is due to a default of the employer or because of a result of a neutral event out with the control of both parties. Take, for example, the one that's obviously cropped up most recently is COVID. Neither party to a construction contract in 2020 could have foreseen that construction sites had to close down. And the answer to that situation will lie within the parties' contracts. Contracts will often provide for a number of scenarios where parties have the power to vary the date in which the contractor is required to complete the works by, so there are workarounds for such situations. And this is where most of the disputes in respect of time arise from. Contractors will, if they are running late, will argue that they were delayed, impeded, or prevented from completing the works on time by a default of the employer. For example, they may say that an employer failed to release design information in time, and as a result, they were standing on site, not being able to progress the works when they were able to, and as a result, they were then late. An employer may, however, turn around and say, well, actually, we may have failed to release the design information on time there. However, you were already running late on another part of the project, and you were so far behind in other parts of the works that even if you had that design information, you would never have completed on time. So the next sector, broad category of dispute is costs. So when engaging into a construction contract, an employer will always be looking for cost certainty and will at all times be mindful of cost control. Conversely, a contractor will at all times be mindful of recovering costs that it has expended in carrying out the works and making a profit on those works. So as you can see, there's an inherent tension between what the employer is looking for and what the contractor is looking for. And that results in disputes when the works are subject to a change and how those changes are valued. Within construction projects, changes are very common. It may be that during the course of the works, the parties find out that the design does not work and has to be altered, or it may be that the employer may simply change its mind in respect of what it's wanting the contractor to carry out. So of course, where changes occur, the contractor will always look to ensure that it is paid for any additional works that it has to carry out under the contract. And it's common that thereafter, the parties will fall into a dispute situation on the valuation of those additional works, or where the contractor is in fact entitled to any additional payment for those works. Take, for example, the employer may argue that a change was required because of the contractor's poor performance. So those additional works were actually only required due to the contractor being unable to carry out, failing to properly carry out the original works. And as such, the contractor should not be entitled to benefit from its own failings. So that brings us on to the final category of disputes, which is over quality of the works. So construction contracts will provide that workmanship and materials will be of a standard included within the contract documents, or sorry, described within the contract documents, and that all work shall be carried out in a proper and workmanlike manner. In terms of professional appointments, those professionals such as architects, engineers and likes will be obliged to exercise the reasonable skill, care and diligence and attention of a qualified professional. So where it's found that works do not comply with the standards described in the contract documents, or where the work has not been carried out in a proper and workmanlike manner, the party responsible is generally required to carry out the necessary remedial works to put the employer in the position it would have been in had it not been for the defective works. However, it's not always simple to determine who in fact is liable for an issue with the works, as I said before. A contractor may argue that the cause lies with the architect or structural engineer's design, as opposed to an issue with his workmanship. The architect or structural engineer or any designer may argue to the contrary. In reality, though, what you'll find, not all the time, of course, but it is possible that issues can arise as a result of both workmanship and design. So that was a quick whistle-stop tour of the three main types of disputes that we come across most often in construction projects. But what happens when the parties can't resolve those disputes between themselves through negotiations? Well, I'm sure you'll have guessed, but in those circumstances, the disputes are placed in the hands of third parties. So I've listed here the most common dispute resolution forums where we carry out the majority of our works. In terms of litigation in Scotland, the majority of our work is carried out within the Court of Session. That's due to the value of the disputes that we deal with, as well as the complexity of the issues. I might have touched on this before. When we're in the Court of Session, we do work closely with counsel in progressing cases to proof. We do also carry out works in the Sheriff Court in respect of lower value disputes. And here we're more likely to carry out our own advocacy as we proceed through the action. We have done works in the simple procedure in the past. However, that is pretty rare given the value of the disputes that we deal with and the complexity of construction disputes. More often than not, you'll find that if you're pursuing a construction dispute via the simple procedure, you're going to be running a loss just due to the upper fee limits within the simple procedure, route. We are also involved in litigation in England and Wales, mostly in the Technology and Construction Court, which, as it says on the tin, is a specialist court principally dealing with technology and construction disputes. So the TCC is where the most technical construction disputes will be heard, and where you'll find most of the leading authority being published. So as you can see, we do undertake work across the United Kingdom. Out with of Scotland just now, we are currently involved in disputes in Woking, London, Manchester, Wales and Newcastle. I think Man has touched on before that we are finding that an increasing percentage of our work is in England and Wales, and that is something that as a team we are looking to build on. On that, within our team we actually have a number of dual qualified solicitors, and the firm is supportive in allowing colleagues to study to become dual qualified. I think in fact just this week one of the associates within our Contentious Construction team qualified in England. So next on the list is arbitration. In arbitration, parties will refer a dispute to a skilled third-party individual known as an arbitrator. Typically, the arbitrator will be a construction lawyer or some other skilled individual with extensive construction experience, as opposed to a judge who may not. The parties' agreement to refer the dispute to arbitration gives the arbitrator the power to issue a decision which is legally binding upon the parties. Arbitration is intended to be less formal than a court action, and as such, it does not have a fixed procedure. The arbitrator is in charge of administering the case, deciding the facts, and applying the law. In recent times, we've been involved in arbitrations with firms that specialise in international arbitration. Whilst international arbitration isn't something that we do a lot of, it remains a forum we are keen to continue to build our credentials in. Next on the list is adjudication. Adjudication is essentially a fast-tracked arbitration process, in that the dispute is referred to a skilled third-party individual and is resolved in a much shorter period of time than arbitration, but I'll come on to adjudication shortly. The final forum on the screen is mediation. Mediation is the only forum listed above that doesn't produce a decision as such. Here, a mediator is appointed simply to facilitate discussions between parties in order to assist parties in reaching a negotiated settlement. The mediator will manage the negotiation process and will help parties to overcome deadlocks, and will encourage the parties to think creatively about solutions. Mediation only works if parties are actively willing to reach a settlement agreement. As such, mediations tend to occur most commonly where parties to dispute are about to start spending a lot of money within their proceedings, such as, for example, where they're about to commence a proof. For example, they know the cost consequences of going to proof. They know the cost consequences if they are unsuccessful at proof, and they know the risks that proof brings. So it's usually around this time that the parties will agree to mediation, sit down and have open and frank discussions about the strengths and weaknesses of their cases in an attempt to reach a reasonable settlement position. So I touched on adjudication on my last slide, but I thought it would be more useful to give you a bit more detailed information, as of all the dispute resolution forums, discussed in the previous slide. Adjudication is probably the one that is least known, well, at least to those out of the construction industry. So the Housing Grants, Construction and Regeneration Act in 1996 introduced adjudication with the intention of preserving cash flow within the construction industry. If you do find yourself involved in the construction industry, you will often hear the statement that cash flow is the lifeblood of the construction industry, and that is correct. So in order to improve cash flow, the statutory right to refer a dispute to, the statutory right was introduced to two parties to a construction contract to refer a dispute to adjudication at any time. So as I said before, adjudication can be described as a fast-track arbitration. An adjudicator, who is a man of skill, is appointed and is required to reach a decision on the dispute, referred to him no later than 28 days after the receipt of a referral notice. The referring party, i.e. the party that has brought the claim to the adjudicator or referred the claim to the adjudicator, can consent to extend this timetable by 14 days to 42 days. However, both parties must agree if the timetable is to be extended beyond 42 days. The introduction of adjudication has led to a marked decrease in what is known as subby bashing. This was where larger firms would intentionally delay making payments to smaller subcontractors, in the knowledge that those subcontractors would not have the resource to fight back via the courts, or those smaller subcontractors would be fearful of fighting back as they may run the risk of not being granted further work by the larger contractors. The unfortunate outcome of this was that ultimately it would lead to a lot of subcontractor insolvencies, because they would be, each month they would be paid either less than they were due or not paid at all, and save as for referring a dispute to litigation or arbitration, which are very costly and time-consuming processes, forums, I should say, they were without any real, they didn't really have any recourse. So the reason that the timescales within adjudication are so tight is that they mirror a typical contractual payment cycle within a construction contract. So that way, if a contractor or a subcontractor is not paid within a payment cycle, for example, it can commence adjudication proceedings at any time, so straight away. It could obtain an adjudicator's decision ordering payment 28 days from referring that dispute to adjudication. So that's one single payment cycle is all they would have to get through, and they could then be ordered payment. So once the adjudicator then ultimately reaches his decision, that decision is binding until it is overturned by litigation, arbitration, or agreement. And the adjudicator's decision is also enforceable in the courts. We do find that it's not very common that adjudicators' decisions are in fact challenged. So it is a very useful method for contractors and subcontractors to get a quick turnaround, a quick resolution to disputes that they are in. We do undertake a lot of adjudication works. It is very interesting work. The timescales are very tight. If you're imagining a mini court action within 28 days, you can imagine the paperwork and extensive reading we have to do in that time, extensive submissions that are due in that time. But it is very fulfilling work, and it is always very, very interesting. So that concludes the forums in which we operate, but I'm keen to touch on what we do and who we work with and what our role actually comprises. So first of all, we advise clients on their rights and obligations under their contract. That is our bread and butter. Most of the times, clients will come to us asking questions that link back to the three subjects of dispute, as we discussed earlier on: time, money, or quality. So we are faced with questions such as, am I entitled to more money? Should I be paying them this? Are they entitled to the money? Can I get more time? Or who is responsible for these defects? From there, we can apply the facts of the matter to the law and advise the client on strategy, how we get them to where they want to be. The strategy may be that they are required to commence litigation proceedings straight away due to an issue of prescription per se, something that Manus is going to touch on in a moment. Or it may be that further investigations are required, and that as part of those investigations, we are required to instruct an expert witness, an expert architect, structural engineer, an expert in renewables to further investigate the matter and essentially work out what the problem really is. We also undertake a lot of drafting within our role, whether that's drafting court pleadings, submissions and adjudications or arbitrations, pre-litigation correspondence, advice notes to clients, letters of instruction to counsel or experts, settlement offers and settlement agreements. So we do undertake a lot of written work. We do spend a lot of time putting pen to paper. And finally, our role does provide an opportunity for advocacy. Whilst we defer to counsel in the Court of Session and the High Court in England and the TCC, we do represent clients in arbitrations and adjudication hearings. In those hearings, we're usually required to provide submissions on behalf of our clients, and we also do get the opportunity to cross-examine witnesses. We do also appear in the Sheriff Court, and we only really do defer to counsel in the Sheriff Court where the matter is of particular high value, or where the matter requires the skill set of a particular skill set of counsel in the specific matter. So in terms of what sort of work we are involved in, I can comfortably say that one way or another, we are involved in every major infrastructure project within Scotland. We work on residential developments. We're involved in the Scottish Hospitals Inquiry. We give advice in relation to disputes concerning the constructions of schools. We've got disputes ongoing in relation to ports and harbours, airport runways and renewables. We have an involvement, or can have an involvement, in just about everything that is being built, every major construction project within the country. Just take, for example, we were involved in advising the designers of the new fourth crossing, which you can see on your screen here. I mean, it's a spectacular feat of engineering, and it does provide us with some pride that we have had an involvement on that project, and it's something that we can look at and be proud of. Touching on that, externally, we work with some of the most creative designers and best contractors in the construction market. That makes the job incredibly exciting. You will come out of each client meeting having learned something new, and you'll come out with a newfound appreciation about just how exciting some of the works that these clients are actually undertaking are. And it's also you also give a bit of pride in terms of how you are contributing to those works. We do also work with some of the top experts within their fields, and we regularly instruct experts in areas such as architecture, structural engineering, and renewables, just to name a few. And engaging with these individuals and getting an understanding of their thought process and how they deal with incredibly complex and technical matters is quite inspiring. Again, you're learning something every single time you pick up the phone to an expert or speak with them on a call or read through their expert reports. It's then our job to take their detailed technical knowledge and apply that knowledge to the law. Beyond speaking with clients and experts, our role does also allow us to instruct best-in-class counsel in Scotland and the rest of the UK. For example, we've recently instructed Serena Cheng QC from Atkins Chambers in relation to a dispute concerning a defective turbine. So you do get exposure to a lot of leading individuals, both inside of counsel, client, and experts. Internally, there is not a team within Brodies that we have not worked with at some point in time, just given the range and nature of our work. So in that sense, our role actually allows for us to get to know all of the other practice areas within the firm. It's not as though we work in silo just within contentious construction. We work very closely with a range of other teams in the firm. So just moving on to the last point at the bottom is, do I need prior experience to join? It's a question that we get asked fairly often, and there is a very simple answer. No, you do not need prior experience in construction or construction law to join our team. We do understand that our role is one that you don't learn about at university, and we're also aware that a number of trainees may not have been able to choose a seat in contentious construction through their traineeship. However, that does not strictly matter. We all learn on the job. As Manus touched on before, our contentious construction team is ranked Tier 1 and Band 1 in Chambers and Legal 500. So in the job, you do have the opportunity to learn from a number of leading individuals in the contentious construction field. You also learn from your clients and experts as you undertake more work. Ultimately, you do become a part of the construction industry, albeit we are the part of the construction industry that nobody really wants to meet, given the nature of our work. So I'm now going to pass back over to Manus, who's going to talk over some current trends and issues within the construction sector. Over to you, Manus.
Thanks very much, Connor. Right, now that hopefully gives you a snapshot of what we do. Probably the things that we do most of is adjudication and advisory. That's the two that where most of our efforts are focused. It's been a very interesting period. We've lived through a period where I've been doing this for 21 years, and if you if you don't know the word force majeure, that's because we didn't really either until last year, until 2 years ago when COVID came out. Force majeure is an event that neither party could have foreseen, and would not have been expected to have priced for under the contract. It's one of the events that Connor talked about, that the contract gives relief for. And one of the first things in COVID was a mad rush to the contracts to see what rights and obligations do the parties have as events unfolded. And as you can imagine, there was no certainty. We lived in 3 weeks. The only thing we knew is that in 3 weeks' time, the government would be reviewing its policy and the decisions it was going to make. And so within that 3 week period, what advice we were going to give, and a group of us met every day online to discuss what we'd seen and questions that had been asked and how we'd answer and how we develop our strategies for responding to disputes, and also what clauses would be drafted into contracts in the future to deal with COVID. And that was a very interesting process. It was interesting to be part of that. We were developing law as it went along. And we thought that was complicated enough. And then, of course, Brexit hit. And then Brexit, of course, brought difficulties as well. If you can imagine trying to get construction products in and out of the UK with the tariffs and the delays that took place as the government struggled to get to grips with the mechanisms of importing and exporting while we were no longer part of Europe. And then, as if that wasn't complicated enough, then we now have a war in Ukraine. Ukraine are a major producer of steel, which is also now impacting directly on projects in the UK. And Ukraine are at war with, Russia's at war with Ukraine, put it that way. There are major sanctions in place. On the 15th of March, for example, if you check on the government website, you'll see that there's notice of new sanctions being put in place by statute, which will block the importation of various materials that are listed. That includes concrete and steel, and various items that are going to, again, directly impact on construction projects in the UK. So as you can imagine, we are constantly advising clients who are in difficulties in projects as to what they should be doing next, what rights and obligations are under the contract, and what you do next. And that is a big part of what we do is giving advice on here is what I think you should do. There's no such thing as being able to stop at saying, here's what your contract says. That's a beautiful clause, isn't it? Nobody cares. They just say, what do I do? And you have to give the advice. And that is why you do develop a lot of sector-specific knowledge, because unless you understand the subject matter you're discussing, how can you give that advice? And that's what Connor was talking about, is why it's important what you learn from those around about you and those within your own team. We're constantly, as a team, we positively engage every day in meetings with, here's what I saw yesterday. Anybody got any thoughts on how this impacts on the advice that we give? So materials, labour, and labour, of course, is Brexit principally as well. It's because a lot of labour left the UK in the run up to Brexit, so there is a shortage of skilled labour as well. So what happens if in your project you can't progress it because you haven't got access to enough bricklayers? So in terms of this is probably the top issue at the minute for us, is materials and labour. Materials more so probably than labour, and we're constantly advising on that there. And you'll see, if you're watching the media this week, we will be publishing articles on that to try and get ahead of the curve, to be the first firm out actively talking about the impact of Ukraine, the sanctions, and the war itself on the construction industry, and how your contracts will respond. Next slide, if you don't mind, Connor. The next thing that's keeping us up at night is prescription. Prescription is keeping the entire Scottish legal fraternity up at night at the moment. And because you're all trainees or NQs, as I understand it, you'll have some understanding of this. The Prescription Limitation Act 1973. Simple proposition is that if an obligation exists for 5 years without interruption, then it lapses, it prescribes, it's no longer enforceable. So the obligation has to exist for the first place to start the clock, and then the clock stops after 5 years. And our world was relatively safe and comprehensible until a case called, the last of 3 cases, which was Midlothian Council against Blythe and Blythe. And what that related to was a construction project, and the fact that whenever Midlothian Council had entered into a contract based on a design that was always doomed to fail, it suffered a loss the minute it signed that contract. And if you think about that, then whenever the defect appeared, if that defect only appeared, for example, I always think a good example is a crack in a wall. If the wall only cracked after 5.5 years, for example, into the project, well then the right or the obligation to pay damages in relation to that crack, that defect, has already prescribed because it's existed for 5 years if it's based on defective design. So where does that leave us? It leaves us with a focus at the moment being under Section 6.4 of the Prescription Limitation Scotland Act, which is where by your actions or conduct you led me to believe that you led me to refrain from enforcing my legal rights. Those periods of time get excluded from the counting of the 5 years. Now, if you think about that, that's so you're actually looking for evidence of conduct or words the part of the defender in the case, which you can then say led the claimant, the pursuer, to not take action. And Connor and I have a live case on this at the moment, which is going through the courts, where court action was raised 5 years and 9 months after the contract was entered into. But for periods in that time, the architect, as the defender, was telling their client, it's okay, there's nothing wrong. I know that things look as if they're deteriorating, but it's okay. So we have evidence of actual communication, the actual words used to let our client to believe within that period that everything was going to be okay. And that takes about a year out of the counting. So in reality, the action that was raised 5 years and 9 months after the contract was entered into was still live, was still valid. The obligation to pay damages had not prescribed. So prescription, and we have new legislation coming in, which we're waiting to see how that will impact on it. So again, live, we are living through periods where the law and how we understand the law is evolving. Now, the third one is cladding. This is a picture of Grenfell, obviously a tragic situation. Grenfell is not unique insofar as the product that was on the walls, because that product had been sold for many years, and therefore there are many buildings across the UK that are covered with Grenfell cladding, as we call it, ACM. And Grenfell cladding is, just so you understand it, and this is the sort of technical detail that we live with, it's a sandwich. It's a sandwich of 2 layers of aluminium with a polyethylene core, polyethylene being highly flammable. And if you imagine that's what you've got on the outside of the building, that's why it is such an emotive subject, and why it's such an important subject in projects where the building has been clad in that product. So if you think about it then, so again, because you are, as I understand it, you're trainee solicitors, and you are trainee solicitors or NQs, you have some sense of this. So if a client comes to you with their building and they have this product on it, and they're saying, can I pursue the contractor, or can I pursue the designer that specified this product? The answer to that very much depends on what your contract says. Does your contract, and the critical thing is, if your contract says that you've got an obligation to comply with, for example, the Scottish building regs at the time when this was constructed, what did those regulations say? The regulations said in Scotland for a long time, until about 2019, they said you could comply with the non-domestic technical handbook, which says you could comply with either the British standard or the European standard, and either or. British standard was much less onerous than the European standard from memory, and so as a result, you could comply with either. So therefore, a lot of buildings have got, a number of buildings have got this cladding on, but technically it is compliant with the building regs. But however, the second issue is, you could say, well, perhaps they were negligent. They should not have specified that. And the two are somewhat interrelated. But if you think about it, the test is Hunter against Hanley. And if there's a way of doing something, and if you've departed from it to such an extent that no other designer of ordinary competence would have specified that product, then that's negligence in Scotland. But if nobody knew, and really until it does appear that there was a period of time when there was an evolving knowledge about this product and evolving concern about it. So at the start, some of this product will have been specified in buildings where nobody in the industry, or very few people, have known anything about it. So strictly speaking, not necessarily negligent to have specified it. And then you're on a sliding scale up to a point where, certainly after Grenfell, where everybody knew. exactly how there was a visual a visual that you could point to, which showed just how flammable and how dangerous this product could be in some circumstances. So as a result of that, you can imagine cladding features heavily in construction disputes at the moment, and in queries that we're answering as to whether or not the product is in fact defective. And in some cases, I think Kingspan withdrew some of their certification in the last year for their products, which means that clients then have to go and get them tested to see does it comply or does it not. Connor and I, at the moment, we've got 2 court actions involving cladding. One's a hotel, one's a prison. So it shows you it impacts widely across the sector. And we've recently been advised in representing the purchasers of a major UK house builder. And that house builder in the past had built flats which were which have got ACM cladding on them. So we were heavily involved in that on the advisory side, just as well as the dispute side. And the reason we did that is because we know more about cladding than anyone else because of the disputes. So wide and varied, as you can see, it changes all the time. The issues that you're dealing with is the dealings with is very, very wide and wide ranging. And I'm just getting a prompt there to say that I need to hurry up. So can we go on to the next slide, Connor?
Yeah, no
If you can, we've only got about 3 minutes. We've got to finish up. And so the last question is, what's expected of a newly qualified solicitor in contentious construction? Connor, do you want to cover that off?
Yeah, no problem. So when I was first joining the team, my main concern was that I was going to spend the majority of my time at a photocopier or printer. I joined the team with 3 months left in my training contract. And my concerns were put to rest very quickly. I've listed here on the screen just a number of tasks that I was actually involved in during my time as a trainee and then proceeding into being a newly qualified solicitor within the team. So you're reviewing and analysing different forms of construction contracts and supporting documentation to allow you to advise on rights and obligations. You're compiling evidence from client papers and witness statements to analyse a factual position or dispute. Instructing experts, revising expert reports, drafting pleadings and submissions, appearances in court, instructing counsel and preparing cases for proof and trial. You are exposed to a lot of interesting work, and that work is seldom straightforward, albeit it is very rewarding and fulfilling work that you're doing. Every day within the team as a school day, you are learning something new with every new file that you touch. And again, you get to work closely with existing clients and you get to help the team win new clients, and you are exposed to really, really interesting and exciting work.
Thanks very much, Connor. Now there is one, hopefully you get a sense for that both of our enthusiasm for the job that we do and a sense of what the project, what the job is. And it's not one that, it's interesting because we probably span more areas of law, I think, than any other specialism. And as a result, it's not one that you will know much about at university. But please do get in touch and do come and feel free to come and apply for our NQ position and come and join us. We'd welcome a chance to meet with you. Now, we have a question. Question is, has construction gotten more contentious since March 2020? And that's probably undoubtedly a reference to COVID. The answer is, bizarrely enough, no. The industry responded amazingly in that period because the sort of advice we got, and this is again, you were trying to work out on a day-to-day basis how new events would impact on your advice, but we reached a point where we were telling developers, yes, you have passed the risk down to the main contractor, who probably will have passed the COVID risk down to the next tier, and they might even have passed it to the next tier, to the subcontractor. But if it's passed down to a level where they can't financially carry it, they're going to go bust. And who's going to build your building? So would you not be better just to leave her a bit of money and to help, give some help, some relief down the line, and be as pragmatic as you can and get your building finished? And that advice worked because developers went, yes, that's correct. That is the right thing to do and is in everybody's interest. And the industry almost universally responded in that way. And as a result, whereas we thought initially there might be a flood of disputes about COVID, there wasn't. There are now disputes about COVID where I suppose it's the impact of a number of things. An impact of that we talked about, the shortage of labour, the cost of materials, the availability of materials have made projects more expensive, and inflation as well. You get to a point now where we're starting to see more COVID disputes because, frankly, contractors or parties have to, because they're feeling the pinch at the moment. But generally, the industry responded amazingly well in that period, and it was it was an exciting time to be part of it. We drafted a lot of settlement agreements where we negotiated, redrafted the contract effectively. We worked with our non-contentious colleagues where we would draft a settlement agreement that would wrap up all the disputes that had happened up to that time, and then the non-contentious colleagues would amend the contract by the new completion date and levering in a bit of money. But thank you for that question. And I think that's the only one. So with that in mind, I would like to thank you all very much for your time, for tuning in this morning. And if you do have any questions, these are our contact details, and please do feel free to get in touch. And thank you very much again.
Thanks, everyone.